What's up everyone, Mark Blankenship with the Ott Law Firm here. Today I want to talk to you about intentional infliction of emotional distress, or commonly referred to as the tort of outrage. So there's 4 elements to this type of tort, which is recognized here in the state of Missouri. And they are as follows. You have to show extreme and outrageous conduct, and you have to show that that conduct was intentional or reckless, and that conduct caused severe emotional distress that resulted in bodily harm. So let's go over each of these 4 elements here. Extreme and outrageous conduct. What that means is basically that the defendant's conduct must be so severe, so extreme and outrageous, that it goes beyond the bounds of decency and morality and is regarded as atrocious and utterly intolerable in a civilized community. And this can also include things such as conduct that is of a sexual nature. The second element, as we talked about earlier, is that the defendant must have acted intentionally or recklessly in causing the emotional distress. Pretty straightforward. Next, let's talk about severity. The conduct must be severe in that it is solely intended to cause severe emotional distress to the plaintiff. Emphasis on solely intended. And we'll talk about why that's important later. And then finally, resulting in bodily harm. That means that the severe emotional distress must have resulted in bodily harm, or in other words, the emotional distress must be medically diagnosable and must be of sufficient severity so as to be medically significant. So merely just having stomach cramps or having nausea is not enough. Usually you have to show that you have severe anxiety that is medically diagnosed, PTSD. One thing to note about intentional infliction of emotional distress is that it will not lie when the alleged conduct is intended to invade other legally protected interests of the plaintiff or intended to cause bodily harm. In other words, basically you can't assert battery and intentional infliction of emotional distress because battery results in physical conduct or physical injury, whereas usually with the intentional infliction of emotional distress, there must be sole intention to cause severe emotional distress and solely that. So in other words, it kind of rules out the physical contact. It has also been held that another tort, for instance, that usually doesn't lie with intentional infliction of emotional distress is defamation. Thank you very much. And again, I'm Mark Blankenship Jr. of the Ott Law Firm. Thanks for tuning in.